Cutting across to some breaking updates also coming in. Supreme Court appointed SIT probing the affairs of Vantara has given a clean chit to the Zoological Rescue and Rehabilitation Centre in Gujarat's Jamnagar. CNN News 18 has also accessed the order copy. Let's go across to my colleague Anand, who's joining us with more on this.
Well, this is big, Shivani, and to our viewers. Vantara has been given a complete clean chit by the two-justice SIT of the two-justice bench of the Supreme Court, and the SIT was led by Justice Chelameshwar, and they have gone through in depth all the allegations and complaints that have been made against Vantara and the about 46,000 animals across various species who are currently being cared for, nurtured and perhaps rehabilitated at the facility there in Jamnagar. Now, just reading some of the important operative parts in this entire 45-page judgment that includes a full Schedule A of all the complaints, news articles, stories, information, submissions that were considered in detail that have also been attached, and all the complaints across various animal species and various concerns from various animals brought in, rescued, rehabilitated from various countries have also been questioned. Importantly, 4.6.3 page 26 says on examination of the complaints, the news reports referred to therein and all accompanying references, the SIT finds no credible, tangible or prosecutable evidence material or documentation has been produced in support of allegations. Complaints and authors were afforded an opportunity to substantiate their claims. The limited material submitted was scrutinized but does not disclose the commission of any offence. One journalist expressly stated an unwillingness to cooperate with courts or authorities. Others furnished only news clippings and secondary articles which in themselves constitute hearsay. At no stage was any material produced that would qualify as material evidence for any further investigation, much less a prosecution or penal measure. The allegations rest wholly on conjecture and surmises on secondary reporting and activist commentary, and none of which have ever met with the prima facie threshold. Now, having considered the entirety of the material placed before it, the SIT has now found anything that would prima facie disclose the commission of any offence to warrant any further action. The complaints are therefore devoid of merit. Very strongly worded. Then all other complaints, 4.6.4, all other complaints, articles, videos and related materials not specifically addressed have also been examined and are liable to be rejected in limine. They are found to be wholly baseless, devoid of even semblance of factual or legal foundation, and the verge of being imaginary. These appear to have been advanced merely to attract attention on the premise that sensational allegations are more likely to gain visibility. And look at the number of people who've been checked or questioned and inquired. In the course of its inquiry, the SIT interacted and obtained inputs from the Collector Jamnagar, the Superintendent of Police, the Secretary Forest Government of Gujarat, the Chief Wildlife Wardens of Gujarat, Assam, Arunachal Pradesh, Tripura, as well as Central Bureau of Investigation, Enforcement Directorate, Wildlife Crime Control Bureau, Director General Forest, Ministry of Environment, Forest and Climate Change, the Directorate of Revenue Intelligence, the Department of Customs, the Sites Management Authority of India, the Animal Quarantine and Control Services, Department of Animal Husbandry and the Central Zoo Authority. And upon careful consideration of the allegations, the responses of these central and state authorities and its own independent assessment, the SIT finds no merit in any of the allegations. No breach or violation has been found of the Wildlife Protection Act 1972, the recognition of Zoo Rules 2009, the guidelines of the Central Zoo Authority, the Foreign Trade Regulation and Development Act 1992, the Customs Act 1962, the IPC 1860 or the Bharatiya Nyaya Sanhita 2023, the Prevention of Money Laundering Act 2002 and the Convention of International Trade Endangered Species of Wild Flora and Fauna. So all these acts have been thoroughly vetted, questioned, inquired, and they have found no misdemeanor or wrongdoing altogether. Further, they have said none of the numerous authorities in India and abroad could support wild speculative allegations. Rather, they express satisfaction on the issues of compliances and regulatory measures. 4.6.7, physical inspection of the facilities and animal welfare conditions also belied the speculative apprehensions. 4.6.8, before accepting any animal and its acquisition, not only requisite due diligence is performed, but also indemnity and donor zoo transferor is specifically insisted and kept in records. And also then there are said 4.6.10, no irregular cash crypto flows, no engagement, I'm just going to increase it again. No engagement with smugglers or unlicensed intermediaries have been brought out. Therefore, the SIT concludes that the allegations made are baseless. The acquisitions are neither vitiated nor tainted by fraud, misrepresentation or contravention of law. 4.6.11. There is no credible, tangible and prosecutable material to prove any wrongful act concerning the possession and acquisition of animals by any donor zoo of any foreign country. However, suspicions have been raised qua local commercial acquisition of animals by donor zoo of foreign countries. Based thereon, doubts are raised on permissibility of commercial acquisition by donor zoo within domestic laws applicable in the respective foreign country. In any case, it is verified that the exports by such donor zoo to Vantara entities in India are under valid sites permit and non-commercial transaction permitted by the concerned government agency and under requisite permissions and clearances. Once the concerned foreign government agencies have allowed such exports and the import thereof is accepted, all concerned authorities in India, there is no reason for Vantara entities or Indian statutory authorities either to go behind the permits, clearances, certificates issued abroad, to investigate, ascertain, issue of possession and acquisition of donor zoo being compliant of domestic laws in the respective foreign country. That means there is no smuggling, no trafficking of any of the wildlife or endangered species who have been rescued, rehabilitated. So it's everything is above board. Just quickly scrolling down to the operative part towards the end, Shivani, before I hand it back to you, this is also important. Towards the end, they have very clearly said, in any event, there is no credible, tangible, 4.6.25. There is no credible, tangible, admissible material to show complicity or knowledge of wrongful act if done any by donor zoo to attract liability, criminal or otherwise, on Vantara entities. Presumption of innocence is hallmark of criminal jurisprudence. It cannot be ignored in this regard merely on the basis of imaginative allegations. Then 2.6 and 2.7 important. Vantara has been repeatedly subjected to various litigations in different courts in alleged public interest with repetitive speculative allegations without any credible, tangible and substantial evidence despite their lawful efforts without any commercialization. The operations of GZRRC and the RKTEWT emerge as legally compliant. Here the SIT also notes that some of the complaints have gone to the extent of questioning the functioning of all the departments of the government, both Indian and foreign. The complainants have also made allegations against the functioning of the court-appointed high-powered committee. They have equally castigated various high courts by making contemptuous allegations regarding various proceedings and process followed by the courts. Such allegations deserve not just complete rejection but deprecation. In the light of the fact-finding exercise, the SIT submits for the consideration of the Honorable Court that the complaints and complaints based on articles, submits, news reports, stories which are considered hereto may please be considered for appropriate orders as already been observed by the Honorable Court paragraph. So thereafter they go out and say please follow the appropriate orders, leaves it to the court, but the SIT finds nothing wrong across all a litany of complaints which they all say have got no legal basis, there is no material evidence, it's largely imaginative and based on hearsay, secondary articles. That's what it's repeatedly said, and all compliance is met, all boxes ticked. Nobody has a problem with Vantara because they have followed all the rules to the T. That's what the SIT has now observed.
The SIT panel that has submitted that report was taken on record earlier today by the Supreme Court.
News18.com marches way ahead of the Times of India with 38% more users on native and social platforms. Network 18, the undisputed leader of news networks, way ahead of the Times.